All right, good afternoon, everybody. This is my week 4 discussion video post. I'm going to start with the explanation of the plea bargaining process. To understand the plea bargaining process, we must first define the term. According to Cornell law, plea bargains are agreements between defendants and prosecutors in which defendants agree to plead guilty to some or all of the charges against them in exchange for concessions from the prosecutors. The plea bargaining process exists for simple reasons. Reasons include it can save the defendant time and money, the possibility of a harsher punishment, and negative publicity that can cause embarrassment. Prosecution also saves time and cost of the trial and ultimately saves tax dollars. And plea bargains also lessens the burden on the judicial system. It would be difficult for the judicial system to have every crime go to court. The process starts when both the prosecution and the defendant negotiate to reach a mutually agreed conclusion. The plea bargain generally results in the defendant admitting guilt to lesser charges. According to Cornell Law's Legal Information Institute, certain jurisdictions allow prosecutors and defendants to work with judges to predetermine what sentences the defendant will get if the defendant accepts a plea bargain. There are a few elements of the plea bargaining, a few valid elements of the plea bargaining agreement. They require 3 specific components to be valid. Knowing waiver of rights, which signifies a waiver of the Miranda rights. A voluntary waiver, which signifies that a defendant is waiving the right to trial. And then it requires a factual basis to support the charges in which the defendant is pleading guilty. The role of judges in the plea bargaining process can change based on jurisdiction, but the judge's role in plea bargaining differs by jurisdiction. As I mentioned before, judges may be involved in discussions between the defendant and the prosecution to assist in the plea bargaining process. Federal judges retain final authority of sentencing decisions, but may not be involved in the negotiations. So it depends on state, local, federal jurisdictions. My opinion on the plea bargaining process, whether it's a benefit or not, I could simply be summarized as I am for the plea bargaining process. People who disagree state that the process infringes on constitutional rights. I disagree because a defendant cannot be forced to make an agreement. There may be some pressure, but the defendants still have an option to a fair trial. The Bill of Rights still pertains to them. They do not have to take a plea bargaining agreement. So that concludes my discussion for this week. I wish everybody the best.